recorded.
Anyone? Okay. All right, so welcome everyone to the Sentencing Guidelines Commission meeting. Today is May 8th, 2025. I'm going to call the meeting to order. Give me a sec, I forgot to open my own agenda. All right, so I'm going to call the meeting to order, and first item on the agenda is roll call. So I'll ask Director Wright to do the roll call.
Roll call, Vice Chair Larkin.
Present.
Larkin present. Commissioner Fraze.
Present.
Fraze present. Commissioner Keefe.
Present.
Keefe present. Commissioner Knutson.
Present.
Knutson present. Commissioner Ladd.
Present.
Ladd present. Commissioner Mazzaros.
Present.
Mazzaros present. Commissioner Middlebrook.
Present.
Middlebrook present. Commissioner Moore.
Present.
Commissioner Moore present. Commissioner Moran. Commissioner Moran absent. Commissioner Mueller. Commissioner Mueller absent. Commissioner Reeves.
Present.
Commissioner Reeves present. Commissioner Saxena.
Present.
Saxena present. Commissioner Mitchell.
Present.
Chair Mitchell. Chair Mitchell present. Madam Chair, there are 11 members present, 2 members absent.
All right, so with that, we have a quorum. First order of business is to adopt the draft meeting agenda. So I would entertain a motion to adopt the agenda.
So moved.
Commissioner Reeves makes that motion. Do we have a second? Commissioner Middlebrook seconds. Any discussion on the agenda? Hearing none, we'll go ahead and take a vote on that.
To the Reeves motion to adopt the agenda, Larkin.
Yes.
Larkin, yes. Fraze.
Yes.
Fraze, yes. Keefe.
Yes.
Keefe, yes. Knutson.
Yes.
Knutson, yes. Ladd.
Yes.
Ladd, yes. Mazzaros.
Yes.
Mazzaros, yes. Middlebrook.
Yes.
Yes. Moore.
Yes.
Moore, yes. Moran. Moran absent. Mueller. Mueller absent. Reeves. Reeves, yes. Saxena.
Yes.
Saxena, yes. Mitchell.
Yes.
Mitchell, yes. Madam Chair, there are 11 votes in favor, no votes opposed.
With that, the motion is approved unanimously. Next item on the agenda is approval of the draft meeting minutes from April 10th, 2025. You should have all received the minutes a week ago and had a chance to review them. So I would entertain a motion to approve the minutes. Commissioner Larkin moves, Commissioner Middlebrook seconds. Any discussion on the minutes? Hearing none, we'll go ahead and take a vote.
To the Larkin motion to approve the April 10th, 2025 MSGC meeting minutes. Larkin.
Yes.
Larkin, yes. Fraze.
Yes.
Fraze, yes. Keefe.
Yes.
Keefe, yes. Knutson.
Yes.
Knutson, yes. Ladd.
Yes.
Ladd, yes. Mazzaros.
Yes.
Mazzaros, yes. Middlebrook.
Yes.
Middlebrook, yes. Moore.
Yes.
Yes. Moran. Absent. Mueller. Mueller absent. Reeves.
Yes.
Reeves, yes. Saxena.
Yes.
Saxena, yes. Mitchell.
Yes.
Mitchell, yes. Madam Chair, there are 11 votes in favor, no votes opposed.
With that, the motion is approved unanimously. All right, so the next item on the agenda is comprehensive ranking review project. I just want to say that I didn't really feel like we had an opportunity to discuss the rankings that we had worked on for the last meeting. So part of the goal of this piece of the agenda is to go back and review some of those again and make sure that we're really getting all of the issues and ideas on the table. And then in addition, Director Wright has some additional information for us to think about as we work on all of these ranking projects. So I'm going to turn it over to staff and have them lead us through the next few items.
Thank you, Madam Chair. I'll begin with an introduction to a paper that was in your materials. It's numbered 4A1, and it's a look at great bodily harm offenses. As the paper discusses, in this ranking project, we've been looking at offenses vertically, if you will. So we've been looking at the same type of offenses. Maybe that offense has different levels of harm, so we've been looking at all those levels of harm vertically. But what this paper does is it looks at offenses horizontally, if you will. So it looks at the same level of harm and then different offenses that cause that harm. And the level of harm that's addressed in this paper is great bodily harm. which, as the paper explains in detail, is severe harm that essentially is going to either cause a permanent lasting impact on you, disfigurement or missing a body part, or it's bringing you very close to death. It's like maiming or mayhem, sort of the old concept of that. So that's great bodily harm. There are several levels of harm below it. There's substantial bodily harm. There's bodily harm causing, well, there's demonstrable bodily harm, which is demonstrable. It's something that you can show somebody, look, I was injured here, or there's just bodily harm, which could be simply pain. But this is the highest level of bodily harm short of death, is great bodily harm. And then we go into the rankings of all these different offenses that where bodily harm is inflicted. And we should note that all these offenses none of these offenses have as an element of the crime that anybody intended to inflict great bodily harm. So essentially, each one of these crimes follows a pattern. This is maybe a bit of a simplification, but I think it's fair to say that each of these offenses follows a pattern where somebody is committing some kind of misconduct. And as a consequence of that misconduct, whether intended or not, as a consequence of this misconduct, somebody else suffered great bodily harm. There are various sorts of rankings for these offenses. It goes all the way from severity level 11 all the way down to severity level 3. And the rational basis for such rankings, I assume, is that the underlying misconduct was different in these situations. So, for example, negligent fires, that's mere negligence. That's often a civil standard. So somebody had a fire going, was negligent about the fire, and as a result of that negligence, somebody suffered great bodily harm. You might think of it normally as the kind of thing that would be a civil lawsuit rather than a criminal prosecution, but it is a criminal offense, and the commission ranks it at severity level 4. All the way on the other side, you have some of these great bodily harm offenses that are ranked at 11, which is, at the top of the charts, if you will, and severity level 10. So very, very high rankings for those two offenses. They both involve assaults on peace officers that severely injure these peace officers, resulting in great bodily harm. Well, it's not just peace officers; it's also judges and so forth. But the people, I guess, who are in the officials group who are most in physical contact with other people are probably going to be peace officers. So they're most likely at risk of this. And when these two offenses were created just a few years ago, the person who was permanently injured was in fact a peace officer, and that was for whom this law was created. There are some very hefty mandatory minimums, almost making the guidelines irrelevant here, because in some cases the mandatory minimums are almost as high as the statutory maximums. So there's very little room for wiggle room there, and they're hard mandatory minimums for causing great bodily harm upon a peace officer. And then the severity level 10 is, and the severity level of 11 offense requires the use of a dangerous weapon or deadly force. And that's the only difference between that and the severity level 10 offense is that the great bodily harm wasn't necessarily inflicted by using a dangerous weapon or deadly force. And as I said, both of those have mandatory minimums. Then you get into some severity level 9 offenses where the underlying conduct was kidnapping, in one case, and assault resulting in harm, which is ordinarily a misdemeanor. And I'm going to be talking about this offense in a bit because it's one of the few misdemeanors, but it's ranked pretty high for the underlying assault being misdemeanor. And as I said, there's nothing in the statute that requires that it's an assault with intent to cause great bodily harm. The intent there was the assault that you intended to either frighten somebody or you intended to cause bodily harm, but not necessarily great bodily harm. And then we have a number of severity level 8 offenses where the underlying misconduct is labor trafficking, drug sale, criminal abuse, malicious punishment of a child, criminal neglect of a vulnerable adult. Now, I should have said earlier, why are we talking about this right now? We're talking about this because some of these offenses that we're talking about horizontally here are in your ranking groups. So offense group two, I'm sorry, offense group one has two of these offenses. There's fleeing a peace officer resulting in great bodily harm, and criminal vehicular operation resulting in great bodily harm. And those, as you can see, are ranked at 6 and 5 here. And they do have lower statutory maximums. So these that are ranked at severity level 8, most of them have 10-year statutory maximums, and I will say 10 years fits pretty well with severity level 8. But when you start having lower statutory maximums, you're gonna start bumping up against the statutory maximum before you get to the grid time in some of these. And then we have negligent fires, and finally we have hinder logging, which is tree spiking, which used to be a thing. I don't know that that's really common anymore. There was one case, if you read the Wikipedia article that I linked to, where somebody did suffer great bodily harm. And that wasn't in Minnesota, but that's just a thing that happened. But it's really interesting to me that it's ranked at severity level 3. That's pretty low for something that I think could foreseeably result in great bodily harm. But then we get to my discussion. These are just my opinions, and I'm not looking at data here. I'm just looking at sort of the elements of the crime and subjecting this to a rationality discussion. And I find a couple of outliers here. So the first outlier that I find, and it's just my opinion, is first-degree assault. And the reason why it seems to be an outlier is it's as if fifth-degree assault was as serious as kidnapping, the way it's ranked. And then you look at these severity level 8 underlying misconduct. So you got misdemeanor assault resulting in harm is the underlying misconduct. It doesn't seem as serious as a lot of these other crimes that there's labor trafficking, distribution of Schedule 1 or 2 controlled substance, criminal abuse of a vulnerable adult, malicious punishment of a child, deprivation of a vulnerable adult. Those all seem at least as severe, and that's understating it, as assault resulting in harm. And yet, assault resulting in harm, when great bodily harm results from that, is ranked at severity level 9. But that's one odd thing about the ranking at 9. The other odd thing about the ranking at 9 is that there's a form of manslaughter that involves committing an assault that results in death. And that form of manslaughter is ranked at severity level 9. So in both cases, the sort of predicate offense, if you will, the underlying misconduct is misdemeanor assault. If great bodily harm results, it's ranked at severity level 9. If death results, it's also ranked at severity level 9. So there seems to be two rationality issues with that. Now, I will say under current Minnesota law, it's probable that you can prove that misdemeanor assault is also a felony assault. So for example, if before the person died, they suffered great bodily harm, then that would be a felony assault, in which case it can be tried as a felony murder. So committing a felony in which death results is a severity level 10 offense. That's felony murder. So that is, I guess, what the footnote 3 is all about. Now, so that's an offense in offense group 3. So that's why I'm spending time talking about it right now. This is an offense that you'll be looking at in offense group 3 later on. But then on the other side of outliers, you have some offenses that seem to be ranked unusually low. And those offenses are fleeing a peace officer in a motor vehicle, driving under the influence, and then this crime that never happened, spiking trees to hinder logging. All seem to be ranked unusually low, and some of that obviously is probably due to the statutory maximum. So maybe this is a legislative recommendation, or maybe it's a re-ranking decision, or maybe it's both, or maybe it's neither. But again, going back to this chart, if you look at fleeing a peace officer in a motor vehicle resulting in great bodily harm, or you look at criminal vehicular operation involving great bodily harm. So you have fleeing a peace officer in a motor vehicle is a felony just by itself. I guess there's a question of whether, these other offenses, particularly misdemeanor assault resulting in great bodily harm, should be ranked so much higher than fleeing a peace officer resulting in great bodily harm. It's only ranked at severity level 6. Notably, severity level 8 is the cutoff for the disposition line, where even defendants at 0 criminal history are presumed that a prison sentence is appropriate under the sentencing guidelines. You know, given the degree of misbehavior here, fleeing a peace officer, and given the result that somebody you know, is basically permanently changed because of that due to the great bodily harm or nearly died. It seems like it's potentially a low ranking, as well as criminal vehicular operation resulting in great bodily harm. Now maybe that's a little more rational because the underlying offense is probably going to be a DWI, which is a misdemeanor, but it still seems questionable that it's so much lower ranked. So that concludes the staff paper. The other thing I wanted to discuss with you is sort of a quick preview of one element of, we're going to be talking about the legislative preview later on in the meeting. But I did want to tell you that I was a false prophet. Earlier this year, I told you that it looked to me like the legislature was going to be making some changes with respect to fleeing. And that's because I saw several different ideas floating around from both the House and the Senate, from both parties. It seemed like it had a lot of energy behind it, and they were getting hearings. So it looked to me like it was probable that the legislature was going to be making some changes to fleeing a peace officer in a motor vehicle this year. However, that we're getting close to the finish line of the legislative session, and most of those crime bills have now been rolled into omnibus bills, and I do not see fleeing in either the House or the Senate omnibus bills. So when you're looking at fleeing, if your decision is based on waiting for the legislature to take action, I'll just tell you that that may not be happening this year. And now hand it to Leah to talk about Offense Group 1 in particular, which we started talking about last week as well.
All right, great. Next slide. So as Chair Mitchell and Director Neat talked about, we are going to revisit and build on the conversation from last month's commission meeting on the Offense Group 1 or the felony motor vehicle offenses, operation offenses. And so the goal today is really to hone in and identify where there is general agreement on ranking of these offenses. We're not going to be voting, just discussion. And a couple of things I do want you to keep in mind. First of all, the U of M has been collecting feedback from practitioners about these offenses, and they will likely be presenting on this feedback at the next commission meeting. And also another thing to keep in mind, that the commission, as they move to discussing criminal history, there's a possibility that the grid might look a little different. And I mention these two things because they could influence ranking decisions. And if that's the case, we can discuss that when that happens. But for now, we want to try to identify where there is common agreement on ranking of the felony motor vehicle operation offenses. So what we're going to try to do here is we are going to throw out some statements or observations that are based on the data from the feedback form, the ranking forms that you sent in, as well as last month's meeting. And we want your reactions to these statements. And we particularly want to hear from those of you who do not agree, but anyone can speak up and see if we can kind of really hone in on where those general areas of agreement are. So does that make sense? Okay. We're going to start with the criminal vehicular homicide offenses, the 5 offenses here. So the observation here is that there is general agreement to keep these offenses ranked at severity level 8, except for the CVH while impaired in prior conviction, which there seems to be a lot of support for upranking to severity level 9. Thoughts, discussion, input?
It's
Pretty clear.
To be clear, the severity level 9 ranking would replace the existing 50% modifier that now exists for that offense.
And what is the numerical change?
You know, there's a chart in materials that we gave at the time. It's very similar. It's mostly higher, except for the very high criminal history scores, and then the line starts to cross. About, it's criminal history score 5 or 6 crosses, but for most defendants, the sentence would be a little higher.
Not hearing anything, any disagreement with that concept.
Ready to move on?
Yeah.
All right, so let's move to the second grouping of offenses, the criminal vehicular operation. Great bodily harm, which includes 4 offenses. So on this, for these 4 offenses, there seems to be some support to uprank gross negligence and while impaired to severity level 6 and keep the other 2 where they are. Thoughts,
And
dissent?
is that
Were you
the
saying
first one or the second? one?
Sorry, the first one, gross negligence. There seems to be support to uprank, and the last one, while impaired. Both to, that would be to severity level 6.
Can I just make an observation about this? So, right now, these are all grouped together as one offense, which if we're thinking about keeping the guidelines simple, it would be simpler to either keep them all ranked the same or to move them all up to severity level 6. But we did give them to you as separate offenses in case you saw a definite distinction in severity between them. But they all involve some kind of criminal vehicular operation, whether it's gross negligence, leaving the scene, defective maintenance, which is a very unusual offense, or most commonly, while impaired.
Sorry, Commissioner Larkin.
So when you say they're separate offenses, meaning that they're under a different statutory subdivision or subpart? And if the answer is yes, we already have circumstances where a statute is split up based on subdivisions or subparts. So
Yep, absolutely. I didn't mean to imply anything's improper about it. It's just going to just make it, people are gonna have to be careful that they're looking at the right subdivision and all that. But it's not a problem at all. If there's a rational distinction in severity between them, it certainly makes sense to rank them differently.
I think there is, and it takes a little bit more work, but it's not a new process. We're accustomed to doing that for other offenses.
Commissioner Ladd.
So the one issue that I would have with, I think they all ought to be together because great bodily harm is sort of the common thread through them. But if they're gonna be split up, one of the things that I see as a challenge or a question on that is that currently the stat max for them is 5 years. And if you look at what the other offenses are at the severity level 6, those offenses, there's one at 5 years, there's one at 7, but all the rest of them range between 10 to 20 years for stat maxes at severity level 6. And so that 5-year stat max seems pretty low and inconsistent with the other offenses that are ranked at that severity level. So that's something that is, I don't know how I feel about that. It seems a little off balance on review of the other offenses that are at that same level.
So what would you do instead? I'm sorry.
Well, I think it should be upranked, but I think that the stat max should, I think there should be a legislative change to change the stat max on that offense.
On criminal operation, great bodily harm, what would you recommend it go up to?
Well, if you look at the other offenses that are at 6, like I said, there's one that has an offense that has a stat max of 5 years. That's a discharge of a firearm at a occupied transit vehicle or facility. That's 5 years. And then fleeing a peace officer, which we're having a conversation about, great bodily harm, that's a 7-year stat max. Otherwise, it's at least twice. I mean, it's 10, 15, 20. I don't see any 25 years in there. So I feel like it should at least be 10 years if it's gonna move up to severity level 6.
Just for
Yes, the ones that
the ones that were.
gross
well, so-
negligence and the WI means while impaired. Yeah. So that's the concern that I have. If we're splitting them out, is that the stat maxes would seem like they ought to change as well.
So just showing the grid here, and not to undercut any of those points, it would fit at severity level 6. It would certainly fit at severity level 6 a lot better than it would fit, say, at severity level 8, where a lot of the other great bodily harm offenses are. Because at severity level 6, the highest presumptive sentence is 57 months. I mean, we do get into, and 60 months is the statutory maximum. So we do get into the statutory maximum above at some of the upper ranges, but But overall, I wouldn't describe it as being a misfit to put a 5-year offense at severe level 6.
Is it 7 right now? Or what is it right
It's
now?
5.
It's 5? 5. I feel like I had a note to increase that too. I don't remember what I had a note to increase it to. That in any of the notes, was there a
Yes.
increased stat max?
Yeah.
It is.
It's in the notes.
Did, were there, what did we say to increase it to? 7. 7? 7. So maybe the 7 that's in my head is what I had suggested. I don't actually remember. Well, so what do people feel about recommending an increase in the stat max?
No objection.
I think it's appropriate.
Yep.
And what number feels appropriate? Oh, 10 years.
Any other comments from those online?
Commissioner Frace?
Just to be clear on, we're talking on which, we were focusing on 2 CVI crimes, and which of them, are we talking about the same statutory max for both of them? Which one are we talking about?
Commissioner Lett, are you recommending it just for the 2 that we're talking about re-ranking, or are you recommending it for all of these offenses?
I'm talking about, yeah, I'm talking about 2 that are being suggested to move from a severity level 5 to a severity level 6.
Okay, so that's criminal vehicular operation resulting in great bodily harm from gross negligence or from a while impaired.
Okay. I guess I'd speak in favor of recommending the increase in the statutory maximum. In terms of ranking them, I realize that we have evidence of public concern about this. It's not a scientific public opinion survey, but people have spoken up. If we look at what practitioners do in these 2 cases, I don't see a high upward durational departure rate. So it doesn't seem like the practitioners, judges and attorneys and probation officers think these presumptive durations are too low. But if we increase the statutory maximum, then if there are going to be aggravated cases that fall into this category, that's what upward departures are for. And you get more room with a higher statutory maximum.
Commissioner Saxena?
I realize I'm in the minority on this. If we're talking about gross negligence, I wouldn't re-rank it, and I wouldn't increase the statutory maximum, despite the fact that I know that this is an incredibly egregious offense that can result in someone being seriously injured. And I guess here's the reason why, and it is that 2 reasons. One is the same one that Commissioner Frace just mentioned. I'm not seeing that practitioners that are actually dealing with these cases or judges are regularly imposing a sentence higher than what we would expect. And number 2, I'm just reading the elements of the offense. I struggle to understand how an increased sentence is necessarily tied to any goal of punishment, like increasing deterrence or preventing this offense from happening or increasing public safety. It is a real travesty every time somebody gets behind the wheel and ends up injuring someone because of their gross negligence. I'm just not sure that that person is thinking about the length of the sentence that was given to the person that did this before they do that, because it's not a volitional knowledge-based or intention-based offense. And so for that reason, I totally understand why the public may want people to pay a more significant price for this offense. I just don't know that increasing the severity level or the statutory maximum will serve the purpose of increasing public safety or creating deterrence.
Other comments? I think I'm feeling ambivalent and I think we should uprank while impaired because that requires prior impaired driving incident. So this is the second time that you've driven impaired, and that's why, doesn't it? Oh, it just means you're impaired. Okay, so you've actually, so this is like the DWI that results in harm. Okay, so that to me the harm is more serious. So I think that I was going for upranking because it felt consistent with the criminal vehicular homicide upranking as well. The gross negligence one, I'm like on the fence about because it's my understanding that some of those are crimes of poverty, that the vehicle has some sort of mechanical problem that the person may not have fixed, and that results in an accident, and that may be because they are unable to repair the vehicle. So it's a very difficult one for me. I'm kind of mixed on that one. Commissioner Keith.
I feel similarly around gross negligence versus if somebody is woefully impaired. So I'm just naming that. I know when we had public comment, Dr. Raj came in and he talked about a specific case. Does anybody remember the name of the folks in that case? And was that a gross negligence case?
I don't know.
Dakota County case.
I think it was Dakota or Scott. I don't remember.
Yeah, folks here are remembering that it was a Dakota County case, but not further details on it.
Okay,
People were killed.
I think so.
Yeah.
I just was gonna look it up to
It was
think about his comments,
racing.
but
And a young couple Easter morning was killed.
okay.
Okay, so this one's a little tougher. So I think we've had some good feedback on this one, and that we have some split ideas here, but not necessarily clear direction. But some folks wanting to uprank both. Okay.
But at least from the
Yeah,
grid, it looks like it's not close on those two.
yeah, correct. Okay, I think we could. Oh, is there another one? I'm sorry, Commissioner Middlebrook.
Thank you. I'm not going to repeat what's already been said, but I would note that on the recommendation to increase it to 10 years, then we're running right into the CBH crimes there at 10%.
Ooh,
Maybe
so I
it is
wonder 7.
So 7 would be still put below that.
Okay. I think that's a very good point. Thanks for bringing that up.
Also, as a reminder, these are your selections were non-exclusive to just one category, no re-rank, up-rank, or down-rank. So it is possible that someone might have selected no re-rank and up-rank at the same time. I want to point that out.
Okay, on to the next
Ready
one.
for the next category? Okay, so moving on to criminal vehicular operations, substantial bodily harm. And as you can see here, this is really a mixed bag. It doesn't seem that there's real clear support one way or the other to change the rankings of these offense. No re-rank was either the most supported option or tied for the most supported option, but you'll see plenty of other up ranks and down ranks. So not clear is the observation, and opening the floor for discussion and thoughts.
Anyone want to make the case one way or the other? Not hearing anything. I see paper flipping, so I'm just kind of giving a second here. I see some folks looking hard at their screens too, so I just want to make sure we have a minute to collect their thoughts. All right, I think we can go to the next one then.
Okay. All right. So then felony DWI, and this is only one offense. And so the general agreement here is to keep the offense ranked at severity level 7.
Any disagreement with that? Great. Move on to the next one.
Okay. And then our final group or subgroup for offense group 1 are the fleeing offenses. And as Executive Director Wrights mentioned, sorry, Nate, there was nothing happened at the legislative session regarding these offenses. So, because a lot of you had written in your forms that you wanted to wait to see what happened in the 2025 legislative session. So, it seems to be that the general agreement is to keep the rankings as is, except for, let's see, great bodily harm. It would seem to be more of a tie vote for no re-ranking versus up-ranking.
All right, Commissioner Fraze and then Commissioner.
It seems like we're focusing in this review on ranking questions. There's the separate question of making recommendations to the legislature. And I guess I'm taking felony DWI as an example. There's a really high departure rate for grid true zeros. And I guess the question is, or maybe that isn't a legislative, even necessarily a legislative recommendation. It could just be a special rule for those cases. But we haven't been talking about anything but ranking just now. I don't know if we're going to come back to talk about other changes that could be made.
I think go ahead and make your point about that. Go ahead and provide that input now. We'd love to hear it.
Well, it's kind of a global issue, and I hope we will at some point be able to address global issues having to do with grid true zeros. I just point but just to preview that, or if we don't ever get to it, I think we've seen a number of offenses now where there's a strikingly big difference between grid true zeros and everybody else, including the non-true zeros. So I think we have a pretty substantial, in terms of the messages, the signals we're getting from the field, from the practitioners and judges. I think when you get in the case of felony DWI, taking that as an example, 87% downward dispositional departure for grid true zeros. So that tells us something. Now, it may be that the other 13% were in one way or another aggravated, and they shouldn't. They're rightly left with the presumptive sentence disposition. So maybe there's no problem here. But if we enter this with, among other things, looking at dispositional departure rates as a signal, something to tell us to look more closely at these cases. And there's a great big signal there. So I guess I just want to flag that at least as a future issue, if not something we're going to fold into the severity ranking process.
Thank you. I do appreciate you bringing that up, and I guarantee you we'll be talking about that. Commissioner Larkin.
I just point out for what it's worth, I think fleeing was an offense that the judges thought should be ranked higher. The thinking being there's really no downside to fleeing. You may as well flee. But the question I have on that is fleeing a permissive consecutive? Oh, I don't know. Is fleeing permissive consecutive?
I don't think so.
I would suggest we think about that. Because we're seeing a lot of people who are injured in these fleeing situations. Granted, they get charged with something else, but it's just like we want to give people incentive not to flee. So if we're not uppranking it, and it doesn't appear that there's an appetite to do that except for perhaps on the bench, maybe we should talk about whether that should be on the list for permissive consecutive sentencing. Not mandatory, just permissive.
What I was gonna say is, I will say that when I filled out this form, I am one of the no re-ranks all the way across the board. But then because this was a topic that was being considered at the legislature, and I didn't quite understand all of the new proposed offenses, I did ask a legislator to explain it to me, what they were after. And what I realized through that process is that the base offense of fleeing, which I believe is severity level 1, it's all the way down there. So base offense of fleeing is the police officers turn on their lights, you're supposed to pull over and you don't, you keep going. That offense though, that could be the guy who enters the freeway in the wrong direction. It could be a person who does some really dangerous driving activity, but gets pulled over before their action results in harm to anybody. And so once that was explained to me, I realized we're kind of missing the offense that is resulting from really dangerous driving, but doesn't result in harm. This version could be anything from you turned right and took 2 blocks to stop to you entered the freeway in the wrong direction before they were able to stop you. So I sort of think there's room for a legislative change here to actually add an offense that deals with that dangerous driving, but doesn't result in harm. I don't know, I got 1 over on that one. But that's all. I got 1 over. Like I finally understood like where they really felt like the issue was. And it was that space where somebody is driving extremely dangerously. They just got lucky and didn't hurt anybody that day.
Yeah. Madam Chair, you're absolutely right. This is one of them that the legislature really should have subdivisions and at different levels, because one person's fleeing, it's the woman that she rolls through a stop sign, elderly lady, and she just keeps going 25 miles an hour in a 30-mile-an-hour zone, and she's fleeing the police officer versus all the other horrible things you can think about when they're going 120 miles an hour down the freeway.
Commissioner Middlebrook.
Madam Chair, just to clarify, it looks like all of those fleeings are on the permissive consecutive.
Oh, okay, so that's covered.
So that is a way to deal with the really egregious driving. consecutive,
When they're charged with the harm.
Yes.
or some underlying offense.
So anyway, I guess that my point is I'm not saying that any of this should be re-ranked, but I wouldn't be surprised if we saw legislative action or, to add something in there that's missing. That was really all I came down on. Any other comments or Commissioner Ladd?
Well, I'll just indicate that I think that the county attorneys, all believe that not only are they ranked too low, but statutory maximums for the offenses for each one of them being broken out is too low as well. I mean, regular fleeing is a 3-year stat max, the next one's 5 years, and then it goes to 7 years. And when you think about sort of the conduct and the resulting harm that occurs and the risk, really, and I will say that most of the cases that we have, it's not just a fleeing offense. There are other charges that go along with it. And I read the comments in the notes that we were given about whether or not there was the panic aspect of it. I haven't come across that and haven't heard of that. I guess there could be that, but typically what it is there's other things. There's a gun in the car, there's drugs in the car, there's a person who is a protected person who's not supposed to be having contact with the person, that person's on warrant status. There's all sorts of other things that really sort of enhance the risk of the behavior that's going on, the risk to the public. And again, I also think that the risk, depending on where you're located, if you're located in an urban or suburban setting and you're going 95 miles an hour in an urban suburban area, that's dangerous. But it's equally dangerous when you're out in the country and you've got Amish, you've got farm equipment, you've got slow moving traffic, and you're not on a straightaway highway. I mean, there's a lot of things, and we have critters out there too. And so there's a lot of things that happen that put everybody at risk. And so I just think when you think of these offenses and the idea that the stat maxes range between 3 and 7 years, it really is, I think it's too low. And so I personally, I voted, since you said we voted, I voted for everything to be upranked, and I voted for a legislative fix. So that's what I put up there. So
What was the legislative fix that you wanted?
I think the stat maxes have to be increased. I don't think that the stat maxes should be 3, 5, and 7. I think they should be at least double that for each one of them. But if they're gonna do that, they also then move it. It would be weird to keep severity level 1 offense to have a 5 or 6 year stat max as an example. So I mean, they're tied together, and that makes it hard. So if you're not gonna do one, it's hard to do the other. That's the disconnect or the connect, however you want to look at that.
Commissioner Saxena.
So I just have a question, and I don't want to sidetrack us too much, but because this is one that I think we're deferring until after the legislative session, but the severity level 1 offense, the fleeing, it's the last one there, 609.487 sub 3. Can anyone from the staff explain why there's such a significant departure rate for that offense? That really surprised me, and I'm not sure I understand why. That
They're not indicating they know. Commissioner Middlebrook, do you have an idea?
Thank you, Madam Chair. I don't know for sure, but I think that what Commissioner Knudsen said was there's such a fact variation. The facts vary so much. And I think that this also was a gross misdemeanor till, not too long ago. And then the legislature made it a felony with a 3-year statutory max. And I think that's why these are all ranked lower. And then because it was a gross misdemeanor, I think that also affects the departure rate too.
Okay, thank you.
And this isn't one of the offenses that the U of M is getting some practitioner input for us on as well. So
I'm sorry, they are or they aren't?
they are.
Oh, okay.
So that might give us more insight as well. Okay, was that the last one on this group?
It is.
Okay, because I want to go back. Commissioner Fraze was mentioning that we hadn't talked about other recommendations. The other thing that I wanted to bring up too is for the criminal vehicular operation and criminal vehicular homicide. Please correct me if I'm wrong, because I did this 2 months ago. There's no conditional release term on those offenses. So a DWI, if you go to prison and then you come out, there is a conditional release term on that. But for criminal vehicular homicide or operation, if you go to prison, come out, I don't think there's a conditional release term, which is an additional period of supervision. And it just feels like if we're gonna have it for DWI, these other offenses resulted in harm, why wouldn't we have the same conditional release term?
Yeah.
So it seems like we should be recommending that, and I really think there should be a review of all the collateral consequences for drinking and driving to make sure that we are treating drinking and driving the same, especially for these offenses where there's harm to victims. That's what I had put in as an additional recommendation.
You're talking about fleeing.
No, criminal vehicular operation and criminal vehicular homicide.
All right, so we've got alcohol use across the board, so why don't we?
Yeah,
Makes perfect sense to have it for the non-harm.
That's my rationale. Why do we have it for non-harm, DWI? I mean, they may have, the difference is you could drive drunk one time and unfortunately that might result in the death of an individual. DWI is you have driven drunk at least 4 times. So you're obviously doing that, engaging in that behavior more, but it just doesn't make sense proportionally for me that we're not sort of treating drinking and driving similar to situations. I don't know what people think about that. But
I would agree with it, and I think it is inconsistent in terms of you're looking at it from a policy perspective as to why it would apply for one category, not the other one. There are a lot of similarities with that.
their input there.
I mean, DWI, because we have the criminal aspect of it, and then you have the driver's license reinstatement and all the stuff that goes along with that. And I can tell you personally from my last incarceration and my release, my absolute hardest barrier was getting my driving privileges back. And I hadn't had an actual DUI since 1993. But I had a test refusal in 99 and then blood drawn in like 2014 or whatever. And that got sent into the state, never charged with DUI, nothing, but it still became the barrier, and I had to have ignition interlock for 6 years for, that wouldn't have prevented anything because meth that was in my system, you know what I mean? And so, there's so many things with that don't make sense right now where they're talking about increasing interlock to 10 years. I get the safety aspect of it. I totally agree with that. However, it doesn't make any sense for somebody that's charged with DUI for a drug offense. Then there's no public safety at all in that. It's just purely punishment at that point, you know? And for me personally, it's $10,000 worth of punishment that wouldn't have prevented anything in the last 30 years. So it almost feels like at times when you see all that, like what's it called when you're punished twice for the same thing?
Yeah.
Yeah. So, and then also the other side of that too, you know, being somebody that works in the field that I do and then the life that I've lived, when you see somebody that's decided to drink and drive and then ends up taking a life and they have less time to serve than somebody that has $500 worth of methamphetamine or $500 worth of cocaine or something like that, that's serving twice the amount of time that in itself seems super unfair that, you know, and so. Yeah, there's a lot to look at in all of that.
Yeah, it's a tough one in that, you know, I think that what I feel like should happen is a review of what are we doing in PWI space versus particular and homicide space. And like, do we have inconsistencies? Should we make some aspects of those consistent? Does some of it not make sense? I mean, I think your point about driving under the influence of drugs versus alcohol is a good one. Or what those collateral consequences. It's a tough one. Right. Any other thoughts on these offenses before we move on? None? Offense group 3?
Two.
Oh, geez.
You're skipping one. We are moving to offense group 2, and as Matt brings it up on the screen, this is a much smaller offense group, 3 offenses, and we'll spend a couple minutes going over the ranking form information that you sent us. I don't think we have time today for a robust discussion, maybe a brief one, but I'll hand it over to Matt to start.
Actually, before Matt begins, I just want to make one quick mini legislative update, since this involves mandatory minimums. It's all about mandatory minimums in this offense group. There is in the Senate omnibus bill, that task force for mandatory minimum sentences is alive in that bill. So it could happen.
Great, so just the explanation of the process. You've all been through this now twice, about three times, but packets were completed for just 3 offenses for this offense group 2. They were submitted to MSG staff by April 28th. And then we organized, condensed, consolidated the responses and tried to make a coherent presentation. So starting with the first offense of this group, registration of a predatory offender, first offense. The majority of, there's the most interest in making a legislative recommendation, but also some interest, some significant interest in not re-ranking this offense, and then some additional up-ranking. Some things, some highlights from this first offense is that legislative recommendation to eliminate the mandatory minimum would be something that would be appealing. There's interest in refining the mandatory minimum for specific situations, including excluding true zeros, probation for first offense, and reserve this for repeat offenders or for lying to the police. Additionally, there's interest in using local sanctions, resources, probation instead of incarceration to allow for redirection and compliance. And then a last suggestion that this offense could be removed from the sex offender grid and moved to the standard grid. On to the second registration of a predatory offender offense, this one being a subsequent offense. There was much more interest in not re-ranking this offense, but additionally making a legislative recommendation had significant interest and an additional interest in up-ranking. And some of the reasons are similar here as what I just spoke to make a legislative recommendation to eliminate or reduce the minimum. The mandatory minimum should be reserved for repeat FRPO offenders, failure to register predatory offenders. This is not a sex offense was a comment that we received, and then also once again remove this offense from the sex offense grid to the standard.
And then finally, the third offense that you all looked at is the certain persons not to possess a firearm or ammunition. We sometimes call it felony gun. And as you can see, again, there was a lot of recommendations for legislative changes, followed by not re-ranking it. And the highlights, and just to remind you, the full packet that went out went in more detail with all the notes and kind of reasoning people gave. So make sure you take a look at that if you haven't. But highlights a legislative recommendation to create subdivisions of the offense. So for example, differentiate between someone who has a loaded gun and an unloaded gun. and comments about excluding ammunition cases and true zero cases from the mandatory minimum. There was also recommendations to remove the mandatory minimums period and use probation for first offenses. And then there were a couple comments about doing more research on the predicate offenses, as well as hearing back from the U of M, who have gathered the research from the practitioners, and hopefully we'll be hearing that at next month's commission meeting. So that is a very quick rundown. It looked a little different than our first offense group. There were a lot more legislative recommendations for this one. So I don't know, Chair Mitchell, if you want.
We are a bit ahead of schedule with our
Yeah.
plan for conversation, so.
Folks have reaction to make on this. Commissioner Larkin.
Understand all the comments that were given. I mean, I saw these cases in district court on appeal, and it's, you just have people that can't comply with kind of complicated things. Then you have people who are just out and out refusing to comply, and it's pretty easy to distinguish one from the other. And I think for the people who are without the resources and without housing, and they're not getting into any other trouble, and they're, you know, readily found when you go out to find them, I think they should be treated differently.
Madam Chair, in my experience, the public safety implications of this crime can be just incredibly divergent depending on the nature of the offense. I mean, the technical offenses, I know my friends in law enforcement would make the arguments about why they should be treated the same way as the blatant lying and misrepresentation, but it was really hard to see that. And unfortunately, fairly or unfairly, some people are just so overwhelmed with requirements that they just kind of check out. And, you know, it doesn't excuse it, but it does raise questions about whether that type of behavior should be treated the same way as people who are intentionally invading law enforcement. So I don't know. I think in this area of offenses, we're really confined by the legislative decision to make mandatory minimums applicable to these offenses. And that makes it challenging. I just think there needs to be a reduction of the mandatory minimums and some delineation between seriousness of conduct, in my opinion.
Commissioner Ladd and then Commissioner Middlebrook.
So a couple of things related to the predatory offender stuff. I was talking to Commissioner Middlebrook about this earlier today, about the rationality. I thought maybe she had some historical information about why these offenses landed on the sex offender grid. Because I do think that there's an interesting piece to that, because this applies to more than just sex offenders, right? So living there, I think, makes it seem like we should probably look at where it would be more appropriately set. I would say that from my own practical experience, most of the time we don't know where these people are at, so we are looking for them. And frequently what I hear is, there are those technical aspects where maybe somebody didn't fill out paperwork or return it timely. Not necessarily the experience that we're seeing. We just don't know where these people are. And that's a concern, because obviously they're at a heightened risk, and the legislature wants you to be monitoring them. And when you can't find them, that is a concern. I do think that looking at the mandatory minimums for maybe the first time failure versus the second, there could be some room to sort of delineate those things. I don't know. I just don't know what that would look like in terms of all of that. So and the other one related to the felon in possession of firearm or ammunition. I will just say from law enforcement, and I was hoping Commissioner Mueller would be here, because I'd be curious to understand what his perspective is on that particular issue. But I do think that for me, there isn't a difference between having a loaded gun and an unloaded gun, because it takes very little time to put a loaded magazine into a handgun and to fire a weapon. And if you've got ammunition, where they say where there's smoke, there's fire. And I just think that they ought not to have gun parts and those sorts of things. I just think it's a recipe for things that aren't good, and it's a public safety concern. And so I think sort of parsing that out, I guess, would be a legislative fix, but I don't know how we would look at those sort of differently. And again, I struggle with both of these, the guns and the failure to register, applying true zero rationality to it, because the reason why there's mandatory minimums, they have a predicate underlying offense, kidnapping or some sort of sex offense or a felony offense that makes them ineligible to have a firearms. I don't know that any true zero cases would be applicable to sort of an analysis of treating them different. So I didn't really understand what that meant. And so I just wanted to make a comment about that as well.
Thank you. Commissioner Middlebrook.
Thank you, Madam Chair. With regard to the failure to register offenses, I would agree with Commissioner Moore that the facts, again, are so different. They're so divergent on what's going on with the person. And I recommended eliminating the mandatory minimum, mostly because it is a low-level offense, and sending them off to prison for 12 months, which usually is less than that because of the fact that they've been in jail. They're not getting any programming, they're not getting anything, and they get out with possibly have lost their job, lost their housing. And we see this so often that's even more disruptive and leaves them even, with less resources. Whereas maybe a local sanction would be better, being able to work with them in the community to, help them if there are these issues. Obviously, there's the other group of people that are just going to never comply and do everything they can to get out of it and just refuse. But you have an awful lot of them that this is just a really difficult, it's a complicated statute. I mean, I think for lawyers and judges, even we all have problems understanding, and it's just very confusing. And we expect quite a lot from these individuals. And I think that when they're on some in supervision, they actually do the best because their agents are helping them with all of the registration requirements. And I think that that's why there's a high compliance rate because of that. So.
Commissioner Keefe.
Thinking about the firearm possession, I think a couple thoughts that come to mind for me are, one of the conversations that we had early on was thinking about separating out, or I guess I brought up the idea of separating out domestic violence from other cases. And thinking specifically about domestic violence, there was a study that came out recently that talks about how the presence of firearms in DV situations can increase the risk of homicide by 500%. And so holding on to that information and thinking about how risk and consequence could be really different from someone who doesn't have DV in their background, I think is something to consider. I think another issue is if we're also saying that folks can't have access to weapons, then also having a space for folks to relinquish their weapons. And I know that that is a big problem right now. There's no, there isn't a good protocol or resource for folks to relinquish weapons right now. And in the DV community, that's a huge topic of conversation. And so as far as legislative changes, like that's a suggestion that resources and protocol is something that's added if we're going to keep pushing, which we should, for that to be a recommendation.
Madam Chair.
Director Wright.
Madam Chair, I'm putting on the screen this is back to the registration as a predatory offender. I'm putting on the screen the rationale by the 2006 commission for putting it on the sex offender grid, which it was creating at that time. It acknowledged at the point that's been made by this commission that it is not itself a sex offense, but it did consider that it believed that predatory sex offenders that failed to register pose a serious threat to public safety. I'm not sure if that's borne out by the evidence or if that was just a belief that they had. And then talks about the commission can tailor appropriate punishment given the statutory maximum sentences.
And what year was this report?
This was the 2006 report to the legislature, Madam Chair, page 18, item number 7.
Middlebrook. Thank you, Madam Chair. Nate, do you know whether or not this was before they changed the name to failure to register as a predatory offender instead of sex offender?
It was.
So I think that was the big key here, why it got put into the sex offender,
Yes, yes, the commission did not take it off the sex offender grid when it was changed to, and the name was changed.
I guess the comment that I would make is that we now have almost 20 years of experience with this law. It does cover more than sex offenses. I mean, many offenses that are tied to sex offenses, but it's more than just that. And I think that we've seen such a broad range of behavior, as has been discussed here today. Some people just not being able to get it together or having housing issues or those sorts of things leading to their violations. Some people purposefully violating, failing, not wanting to register. I think taking it off the sex offender grid makes sense. And I also think that we should recommend the legislature try to parse out the behavior more to give us those options. I could see having a mandatory minimum on that more willful behavior and not on the other type of behavior. And the devil would be in the details on how you write it, of course, but that seems to me, seems like it's time to go back and revisit how that statute's be my recommendation. All right, I think that covers that topic. Let's on to the next one.
All right, Madam Chair, I'm going to briefly introduce Offense Group 3. I'm not going to actually even show it, just in the interest of time. We do have to get through, but I have several pieces of bad news with respect to Offense Group 3. First of all, it's very long. Okay? We did that because we wanted to give you the opportunity to look at these offenses where they're kind of all lumped together. Like if you look at assault in the 3rd degree, it's assault resulting in substantial bodily harm, it's severity level 4. Yeah, but there's a lot more to it. There are offenses involving child abuse in there. I mean, so there's lots of different ways to break up the offenses. And we erred on the side of kind of carving it up for you. There are a number of recurring themes in there as you look at as far as re-ranking considerations, we call it. One is, we've got a lot of stuff ranked in severity level 4. We've got offenses resulting in substantial bodily harm ranked at severity level 4. We've got repeat misdemeanor assaults ranked at severity level 4, domestic assaults ranked at severity level 4. We've got, and then we've got repeat violations of protective orders that do not result in harm, but well, they may result in fear, but the violations of protective orders are also ranked at severity level 4. So, are there distinctions that should be made based on those offenses? There are also a lot of assaults in there, and the question that I would ask you to consider is there are 3 different ways of committing an assault. It could, so for example, take 2nd degree assault with a dangerous weapon. That could be assault by fear, basically somebody intentionally inflicting fear in another of great bodily harm or death by threatening somebody with that weapon, but not actually causing any harm. There's also an attempted assault, so where somebody maybe swings at somebody with a knife but misses. That's also an assault with a dangerous weapon. And then there's assault resulting in bodily harm. So if somebody, say that same example with a knife, stabs somebody with the dangerous weapon, but doesn't inflict substantial bodily harm or great bodily harm. So that would be a 3rd type of assault with a dangerous weapon. And all those are treated the same by the guidelines. Both that comes up in 5th degree assault as well, should there be any distinctions that are made. So that's bad news number 1 is there's a lot of work for you to do in there. Please take your time and look at it very carefully. Bad news number 2 is please don't take too much time, because we are anticipating a huge amount of work potentially. I'll get into this in the legislative update for staff getting ready for the June meeting. There's a lot of work that you're going to have to do at the June meeting, and so we can't give you as much time as we gave you on Offense Group 2. So we're asking you, so the 16th is a Friday. If you get your work done during the work week, please have it to us by the 16th. If you work on the weekends, please have it to us by Sunday, the 18th. But we really need to start working on it on Monday, the 19th. So we really need to have it in by then. So please, please submit those to us by that deadline. Thank you, Madam Chair. That concludes staff's presentations on offense group 3.
All right, next item. Before we go to the next item, we did forget to include in there the update on what the steering committee is doing. Commissioner Middlebrook was going to give us a quick update on that work that we did today.
Yes, we had a very productive meeting today. Very engaging conversation and discussion about whether we wanted to relook at the standard grid and kind of change that. We went back and forth and kind of came to the conclusion that we were going to keep the standard grid. We talked a lot about the true zero and whether or not we wanted to include a category on that or recommend that. Kind of still going back and forth on what to do with the true zeros. And if you don't know what a true zero or don't understand, you can talk to me later and I'll try to explain it. Or Professor Fraze is always a good resource on that. Possibly putting in or recommending a mitigating factor for the true zero situation for both dispositional and durational departures. We agreed that we would like to include the ranges in the shaded areas, which right now there's just a fixed number in there that we would recommend that we do the ranges. And we also are looking at the custody status, not getting rid of custody status, but taking it out of the actual criminal history and having a separate column that would basically be the equivalent of what it is now, but it would, for each of the severity levels, would have a number in there that they would get additional time. That way, it would be an increase in the sentence because of custody status, but not moving anyone over the dispositional line. So those are some of the things that we talked about and came to some conclusions and are continuing to discuss.
We'll move on to item 6, which is item 5, which is the legislative update.
Thank you, Madam Chair. So I provided to you a document that basically summarizes the two omnibus public safety bills, one from the bipartisan House, I think is the accurate way to say it. It's split evenly, Democrats and Republicans, and then the DFL-led Senate. And the two bills are quite a bit different, as you can see. But a couple of things I'd like, just in the interest of time. I mean, obviously, we don't know what's going to pass here, but this bill is in conference committee right now, so they're working out the differences. The significance of which is this would be a chance if you wanted to make any legislative recommendations with regard to any of these bills. This would be your chance to do it. You've already made a recommendation with respect to that third one on the first page, the task force on mandatory minimum sentences. I do intend to write a letter to the conference committee, letting them know that, but I wanted to wait just to see if you had any other recommendations. A couple of things that come to my mind and you know, can completely disagree with it. This 10 and 12-year mandatory minimum sentences for sex trafficking first degree and aggravated sex trafficking first degree. So we have those ranked at severity level B and A on the sex offender grid. And at level A are first degree criminal sexual conduct, which also has a 12-month mandatory minimum. So actually that would kind of line up with the sentencing guidelines pretty well. And at severity level B, we have offenses that have a 90-month mandatory minimum. Now they're going with a 120-month mandatory minimum. It would actually line up a little bit better and make it easier on the guidelines and practitioners if that were a 90-month mandatory minimum. I don't know if being easy on practitioners and lining up the guidelines is something the legislature should care about. But it did seem to me that it might be rational to recommend to the legislature changing that from 120 months to 90 months to line up with the mandatory minimums that apply to second-degree criminal sexual conduct. The other issue that I see is possibly being the type of thing that there might be a recommendation for is this offense here. So there's a crime called revenge porn, and basically what they're doing is merging revenge porn with coercion. If somebody disseminates private sexual images and it results in great bodily harm or death, and I think we're probably talking about a suicide situation here. That's how it's come up in the past. Then that's a new offense. The problem is great bodily harm or death. The commission ranks offenses typically based on the level of harm. If they lump one offense together in one provision without any enumeration, it presents a ranking challenge for you. So my suggested recommendation to the legislature might be to break up bodily harm and death into separate enumerated paragraphs or subdivisions or something, so that you can rank one and then rank the other, and it's clear what's being ranked. So I throw those out there for your consideration, but otherwise that concludes my legislative update.
You need a motion for that, or?
You would, if you wanted to make those a recommendation that I can pass along on behalf of
Make
the
that
commission.
motion.
Okay, so just for the second one, not for the 90-month thing.
For both.
Okay,
Second for both.
Commissioner Ladd makes the motion to make the two recommendations as described by the Director Wrights, and Commissioner Reeves seconds. Is there any discussion on the motion?
Can you restate the motion?
yes, I'll restate it. So the LAD motion is to, that the commission recommends to the legislature to change the 120-month mandatory minimum for first-degree sex trafficking to 90 months, and to break up great bodily harm and death in the coercion offense changes under separately enumerated subdivisions or clauses.
Any discussion on the motion? Keep looking at you. Hearing none, I guess we can go to a vote then.
All right, to the LAD motion that I just described, Larkin?
Yes.
Larkin, yes. Phrase?
Yes.
Phrase, yes. Keefe?
Yes.
Keefe, yes. Knutson?
Yes.
Knutson, yes. Ladd?
Yes.
Ladd, yes. Mazzaros?
Yes.
Mazzaros, yes. Middlebrook?
Yes.
Middlebrook, yes. Moore?
Yes.
Moore, yes. Moran? Moran, absent. Mueller? Mueller, absent. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 11 votes in favor, no votes opposed.
Great. With that, the motion is approved unanimously.
Right. We do have a demographic impact statement in your packets for you, Madam Chair. That bill isn't really alive at this point. I don't see, it's a really interesting bill. It takes the list of crimes of violence, and I always put that in quotes because primarily because in that list are also Chapter 152 drug offenses, all Chapter 152 drug offenses, which have no element of violence in them. Some of them do, but certainly not all of them. And it eliminates Chapter 152 drug offenses. It has a very significant prison bed impact, and also has an interesting demographic profile, which you can read about in the demographic impact statement. And other than that, Madam Chair, I could move on to the Executive Director's report.
Before you do that, I just want to highlight, because I'm not sure if you said it or not, but for those of you who are new, our June meeting is lined up with the end of the legislative session. So a lot of what we're doing is looking at, are there any new offenses to rank or not rank? We do that on a preliminary basis, and then we move forward. Anything that we rank moves forward to a hearing in July, and that's how we finalize the new set of guidelines for next year. So that meeting is going to be normal time, right?
Yes.
1 o'clock. We won't, that will be our primary function, like we have to get that done. So if that takes the whole meeting, it takes the whole meeting. If we have time to do other things, we'll do other things, but that's what we have to do. It's, I just want everyone to be focused on June has a purpose, and we will make sure we get that purpose done in June. So now you can move on to your executive director's.
Well, that just concluded my executive director's.
Oh.
I was gonna you all. So I will be asking for RSVPs for the next month's meeting. We do quorum, not that there's been a problem with quorums lately, but we absolutely need a quorum, and we absolutely need you to read ahead, because there will be a decision made at the end of that meeting. Assuming there are decisions to be made.
Assuming.
Yeah.
Yeah, assuming the legislature does anything, yeah, I mean, there's a couple of things here. One is the House might not agree with anything, and there's might not be much to go along with. The other option is they won't come up with comprehensive budget targets, and so they won't let the budget pass out of the Public Safety Committee, which would make me very sad, because my salary and the salary of my folks here are included in that bill. So we'd like to see it pass, there might be really nothing to talk about in June, but there might be a lot of work. I mean, the Senate has a lot of bills here, and I don't know that there's going to be much opposition to them. So it's possible that we'll have a lot of work to do to basically conform the guidelines to the legislative changes and rank offenses.
It's June 5th.
Double check.
Yeah.
June 5th. June 5th.
At
That's
1
correct.
o'clock, so 1 o'clock is the time, as the chair just said.
And just to make sure that everybody's head is in the game, July, we have 2 meetings. And that's because if we do rank any offenses in June, we have to hold a public hearing on those. Then we have to wait a week for any input that the public might provide. And then we do our final vote to approve or change or whatever. We're gonna make our final decisions a week later. So we have 2 meetings in July, and those are July 17th and 24th. And again, the ranking will be, any ranking, any changes to the guidelines are our primary function at those meetings as well. But if we have time to do other stuff, we'll keep working on the comprehensive review around it. So, so that's what the next 2 months look like.
Yeah, so if you're confused by that, why are there 3 meetings? Your decision in June is a preliminary decision. Then you get the public's input on your decision, and then you make a final decision a week after that.
And we have rules about how long the guidelines have to be posted to the public before we can finalize. So that's what sets the timing of the hearing, and we have to have everything out for 30 days and all of that stuff. But that's part of the rulemaking process that maybe someday we'll make that process go a little faster. We'll see. Okay. Any questions before I move on to public comments? None? We will go ahead and open it up to public comment.
All right, Madam Chair, there aren't very many members of the public on. That's probably because we're getting cross-programming with the conference committee on public safety. That's probably happening at this very moment in the Capitol. Julia, if you have any comments, you could raise your hand. I'll just unmute you because I think you probably do have a comment. Dr. Laskowski, do you have a public comment?
Sorry, can you hear me?
Yes, we can.
Okay, I don't have anything specific to say. I just wanted to mention that I am wrapping up my interviews with the practitioners, prosecutors, defense attorneys, as well as some DISPO advisors across the state. I should be able to present at the June meeting, although it kind of sounds like you might be busy, but we can chat about that. And the 5 offenses that I have been getting feedback on are aggravated robbery, 2nd-degree assault, felony DWI, criminal vehicular homicide and failure to register. So I've gotten a lot of great data, and I just want to thank Catherine and Kira for connecting me to prosecutors and defense attorneys across the state.
And I want to clarify that I misspoke earlier. We don't have information coming back on fleeing a police officer. So that's not one of the things that will get researched on. Great. There's nobody else? Anyone else online?
Nope, nobody else is online.
All right. With that, we have come to the end of the meeting for today. So I will adjourn and I look forward to seeing you all in June. Thank you.
Names in here now.
Yes, yes.